morning or good afternoon, everyone. This is Hannah with ISSA. We are very pleased to have IntelliCorp with us presenting this webinar today. Before we get started, I'm going to go over a few housekeeping items. Today's webinar will include Q&A following the presentation, so please feel free to submit questions throughout the presentation to be answered during the Q&A. To submit a question, click on the private tab within the chat area in the lower left corner of your screen, and double-click Leaders and Assistants, and then you can type your question in the bottom text box, and then you can hit Enter. So today's session is called, Am I Conducting Background Checks the Right Way? Top 5 Best Practices for Background Checks. You want to hire qualified and talented people to help your business succeed. This session will cover 5 best practices for background checks that you should consider when conducting employment screening. Employers must keep up with an ever-changing legal landscape concerning laws and legislation, in addition to providing a fair and balanced review of an applicant's background. You'll learn why it's important to create a background screening policy, comply with legal guidelines, be consistent, establish criteria to evaluate background check results, and conduct regular screening program audits. So here from IntelliCorp today, we have their sales manager, Matt Garbinkas, to take it away. Thank you so much, Matt.
Thank you, Hannah. Thank you for having me today, and thank you to everybody that has logged into the session. And we're going to cover exactly what Hannah said there, and hopefully we'll be able to provide you some useful information that's going to help you with your background check process. Some of this may be a little bit of an overview of some of the things you might already know, but hopefully we can give you some new information that's going to really help you accomplish what you need to do when it comes to doing your background checks and doing it correctly. So I will get started. Well, first of all, it is, as an employer, you do have an obligation to maintain a safe working environment, and background checks are just a part of that as far as making your workplace safe. Some of those risks that you are trying to avoid when hiring somebody and by doing background checks, you want to avoid theft, violence, lost business and customers, negligent hiring claims, and even that time you waste when you're recruiting and the whole hiring process itself. Because as we all know, that does take time and money to train somebody and bring them on board, and then if you have to do that process over again because of a poor hire. And Hannah did mention that paragraph below. As far as employers, you are looking to hire qualified and talented people, and these 5 best practices are going to help ensure that you are in compliance with laws and that you do provide a fair and balanced review of an applicant's background. Number 1, create a background screening policy. You definitely want to have a policy in place and put it in writing. It's very important to have that in writing. You may even want to consider putting it as part of your employee handbook. It needs to be available to anybody that's going to affect or that's involved with the hiring process. So you want to make sure it is in writing. You could also create a list of the types of background checks that may be required for your organization, whether it's criminal checks, motor vehicle reports, credit checks, etc. And you could even break them out by position, because you want to do or be consistent with your process, and categorizing some of the positions that you have may help you with that. Okay? You also want to choose a background screening provider that's going to best fit your needs. So you definitely need to determine which services you're going to need and be sure that that vendor can provide those standards you require. Also be sure that they're going to help you with compliance and being and following those applicable laws and guidelines that are out there, and I'm going to get into that in a little bit. It's very highly recommended that you also use an accredited company through the NAPBS, which is the National Association of Professional Background Screeners. They do have an accreditation program in the industry that sets certain standards for their members. So that is definitely something you want to consider to help reduce any of that risk that is out there when using background checks for this purpose. Okay, and as always, the disclaimer is going to be to seek legal counsel to help develop your own customized policy for your organization, and any other questions you may have specific to laws that may pertain to your industry or even your state or otherwise. Now, as far as when you create your background screening policy, here are some of the benefits of why you should do that. First of all, it's going to cover your decision. Thorough background checks provide a basis of proof of your hiring decisions, and in cases of negligent hiring, an employer can use their findings as valid evidence as to why someone was hired or not. It also offers transparency. If the hiring process is questioned or seems unfair to certain protected classes, that policy is going to show from beginning to end why a person was fit or not for that position based on their background. And without proof, it's simply your word against theirs. And based off of the Fair Credit Reporting Act, which I'm going to get into a little bit, the FCRA is very heavily weighted in the consumer's favor. So if you don't have proof or showing your process or your decisions of why you did what you did, the advantages to the consumer in those situations without that type of proof. So very important to keep that documented. The other thing is that it maintains fairness and consistency. So all your hiring decisions should be fair to all candidates. And having a written policy that includes the entire process is going to stand a much better chance of being fair and consistent, and to avoid that any litigation if possible. The other thing is it also protects your reputation. First of all, negligent hiring lawsuits can ruin a company's reputation, but also it can be a benefit for your clients. If you do make them aware that you're doing these background checks, it can also protect you that way as well. So all those things definitely play into that role as benefits of why you should have that policy in place. Number two, comply with legal guidelines. There's a lot of different guidelines out there that pertain to when and how you use background checks, and here are a few of those pieces of legislation or the policies you need to follow. First of all, I touched on FCRA, the Fair Credit Reporting Act. That is the legislation that regulates background screening and outlines how you use the information and different procedures you need to follow. The ADA, or the Americans with Disabilities Act, also is something to consider. That's the rules that prohibit discrimination against people with disabilities. Ban the box is a very hot topic lately in the, well, across the country, quite frankly, and that's the legislation that involves removing the checkbox from an application asking if someone has a criminal history. I'll get into that as well in a little bit. Credit reports, if you're using credit reports, some people use those for certain positions that have either financial access or access to sensitive information. But there are some states that have restrictions on using credit reports for an employment purpose. E-Verify, if you're not familiar with E-Verify, that is the verification that someone is eligible to work in the U.S. It goes along with your I-9, but E-Verify goes a little further than that. So there are some laws and guidelines that pertain to that as well. And social media, if you're using social media as part of your background screening, there are also some restrictions there to be aware of. And that does sometimes pertain to certain areas, mostly state regulations. As far as the FCRA specifically and legal guidelines, just to go a little deeper into that, the FCRA is a key component of any background screening program, and remaining compliant with that is essential. Those requirements include the procedures that employers must follow before you're even ordering a report. There's also steps that you must follow that as far as how you're going to use the information and things you have to do to notify the consumer or the applicant, and I'll touch on that in a second. Consumer reporting agencies like an IntelliCorp, we also are called CRAs. We have regulations and guidelines we have to follow as well when using this information for that purpose. And the FCRA is a federal guideline, but there are some states that have their own version of it at the state level that would serve as a supplement to that federal guideline. And right now, I think about 21 states have their own version or supplement to the federal FCRA. So you need to be aware, obviously, if you're in any of those states, that if there are any specific rules you need to consider. Now this slide has a few pieces of information as far as the procedure you need to follow. And some of this is going to be known, and I think that there is a piece of this that is more widely missed that people may not be aware of, but I'll go over some of that. But first of all, you have to have disclosure. So if you're going to be running a background check in your hiring process, you have to have disclosure, and that disclosure needs to be clear and conspicuous and in writing. Okay, it should be a document that consists solely of that disclosure and not include any extraneous information like a hold harmless or a release of liability or anything like that. So make sure it's a clear and conspicuous document that's separate from anything else, including or especially an application. It shouldn't even really be paper clipped to the application. It should be very clear that it's a disclosure that a background check is going to be run. Second is that written consent and authorization. You must have written consent from the candidate before you do any background checks. And that also needs to be a separate page that is solely of that consent and authorization and not include any extraneous information, just like the disclosure of a release of liability or anything like that. Now you can actually, according to law, you can have that authorization line or the signature as part, excuse me, as part of the disclosure. But really, that's the only thing that can be combined here or be included on either one of those forms. So please be aware of that. If you have anything different or on your form that you think shouldn't be there, then definitely adjust your forms accordingly. Now this next bullet is probably the most missed or misunderstood as far as the process that needs to be followed, and that's a pre-adverse action notice. So if you find something in someone's background check that may disqualify them from the position that they're seeking, a pre-adverse action notice needs to go out to that candidate. Now, with that notice needs to be a summary of their rights and a copy of the report that's in question. And by giving advance notice, you are giving that person the opportunity to review and explain that particular instance. And I'm going to get into this a little bit further in the next slide or two when it comes to why that's important. But you do need to give that person the opportunity, because if there's an inaccuracy or something, if you're seeing something you shouldn't have, then that candidate has the right to dispute that and explain that and give you that information. And then that needs to be part of your decision as well. Now, if there's, and as far as that pre-adverse action notice, the FCRA states that you need to give a reasonable amount of time for them to respond to that. A reasonable amount of time in the industry is at least 5 business days. We recommend 10, but you do have to give them time, and that reasonable time frame is a little bit vague, but as far as precedent goes, and with different cases out there, 5 days should be the very minimum that you allow for that person to respond to that pre-adverse action notice. Now, if the decision is made the final decision is made not to hire that person because of the background check, then that post-adverse action notice goes out, again with their summary of rights, the copy of the report. Include the information on the vendor or the provider of the information and the report. That gives the candidate opportunity to contact that company if there's an inaccuracy somewhere. And then also you want to make a statement on there that that provider didn't contribute to the decision, they just provided information on the report. Those last 2 steps are required if you're using information for an employment purpose. So if you're not doing a pre-adverse action notice or even a post-adverse action notice, you definitely need to start doing that. Now the EEOC, and I think everyone knows who the EEOC is. They actually are, well, Equal Employment Opportunity Commission. They have guidelines that also have to do with the use of criminal background checks for an employment purpose. They updated those guidelines in 2012. So if you're not aware of those updates, you're obviously a little bit behind. It's been 5 years now, but those guidelines and those updates are what I want to cover. Now, the main thing that those guidelines are what changed, as far as excluding applicants based on a criminal conviction must include an evaluation that such exclusions are job-related for the position in question and consistent with business necessity. You also need to consider the nature of the crime, the time elapsed since the crime happened, and the nature of the job that's being sought. So that's part of that assessment that I was talking about with the pre-employment screen and all that. So you want to, they actually call it an individualized assessment, and that needs to be part of your process as well. And there is a link here, and this is, I believe this is going to be provided as far as if you want a copy of this presentation. There is a link that the FTC and the EEOC put together. It helps you understand what you need to know when it comes to some of these rules and regulations I spoke about. And it gives you a little more of a layman's terms as opposed to the actual legal document, the FCRA legal legislation. So it's a little easier to read and puts it a little better in a better explanation for you. Ban the box. I touched on this before. Ban the box is, again, removing that question from an application on whether someone has a criminal history or a criminal conviction on their record. At this point, it's best practice just to remove that checkbox from an application altogether. Ban the box is actually, there's states that have specific ban the box laws now that actually dictate when you're allowed to ask that question. For instance, some states or municipalities or cities have a law that says you cannot ask that question until after a first interview. Other states or areas have their rules are you can't ask that question until after a job offer. And actually, I just read an article this morning that it was there is a consideration for a federal law to be in effect for that ban the box. So they are starting to talk about that on a federal level, which seems to make sense because the majority of, well, almost the majority of states now have some sort of law, and they're all different. So being able to kind of set a standard on exactly what ban the box means as opposed to having all these different rules in different areas would make sense. Okay. Now also the EEOC guidelines state, well, the rationale behind that is that you're more likely to objectively assess someone on the relevance of their qualifications and experience and give them a fair shot, and then use that information later in the process to do that individualized assessment. So it's just a better process to give people a more fair shake at a position as opposed to making a decision on a checkbox. Number 3, be consistent. Following your written policies is going to help you ensure that you are consistent in your screening process for all positions. It's also going to help because it is in a written policy is going to help your consistency, especially if there's multiple people involved with the screening process. So this is just going to help you be consistent across the board, and everybody's going to be doing the same thing on every situation. An all or none situation means that if you're going to be doing a background check on one person, you're going to be doing it on all, or especially if it's by position or categories of position. Again, make sure you're not discriminating and you're running background checks on everybody if you're running on anybody. And that just kind of goes along with that third bullet that if applicants are applying for the same job, they should all undergo the same background check. It is important to realize that not all positions are the same, and there will be some different things you may need to run based off those decisions, whether, let's say, it's a driver and they need a motor vehicle report where a non-driver wouldn't. But be consistent with what you're doing for those position categories. Then you want to develop those specific standardized searches that are going to happen for those specific job categories, and make sure you review the nature of the job as well, and that individualized assessment is going to come into play there also. Number 4, set criteria to evaluate screening results. Like I said before, you're going to determine the standards that will either qualify or disqualify your applicants, and that could be by position again. But this will help eliminate those judgmental decisions to remain consistent. You want to examine each case individually. I already touched on that a little bit, but again, there's green factors when it comes to those Eeoc guidelines, which are, again, the nature of the crime, the time elapsed since the crime, and the nature of the job being sought. That should be part of your process, and that's why I reiterated that. And then your decision should come down to how the criminal history relates to the responsibilities of the job in question. So, for instance, if you're a daycare and you find that someone is a registered sex offender, obviously that's job related. You wouldn't hire that person for that role. But if they fit in another role within the company, then that should be a consideration as well, where that might not pertain to the duties that they would be assigned to. And just as a side note, arrest information should not be used in your final decision. Conviction information should only be used. Some areas restrict seeing arrest information. And quite frankly, arrests can turn into a non-conviction or a not guilty or even a dismiss type thing. So making a decision on arrest records is putting you at risk of not hiring them for the wrong reason. Number 5, conduct regular screening program audits. So with all that being said before, there's a lot of different things to consider. Those laws do change. There are different things that happen, like I mentioned, ban the box is an ever-changing thing lately. More and more areas are adopting that policy. So you want to make sure you're in line with those different rules and regulations that do change. Every year or maybe every 2 years, take a look at what your policies and your procedures are, and then identify any gaps that you may have and make updates to your program. And also make sure that you keep information about applicants and employees confidential. That's another piece of this that's very important. You don't want that information getting into the wrong hands, because there is a lot of sensitive information there, especially personal identifiable information as well, like socials and so forth. Being proactive is part of that, and that's just keeping up with those laws and regulations and your own program specifically. And then that just monitoring that legislation and continuously updating your policies will better position your company to be consistent and in compliance with all applicable laws and guidelines pertaining to the hiring process. So with all that being said, that final paragraph is just kind of highlighting or summarizing exactly why you want to do all that. Now, as far as what we're offering to the ISSA members, I'll just make a quick mention of what that looks like. The standard package that you see on this screen is a criminal background check. We do offer other products, and you can see at the bottom there's other products available, like motor vehicle reports, credit checks, and so forth. But just to kind of give you an idea what this package includes, so you understand it better. First of all, it's a very nice discount. You're getting a great price because you are a member of ISSA. The middle column there for that standard package is our most common package, so that's why I'll touch on that. But a validated criminal database. A lot of times I get asked about, well, I do a database search and it's nationwide. Well, first of all, that's not really possible. No one has a database that covers everything everywhere. The other thing is, if you do have a database, that information can get outdated or sometimes be inaccurate. So you want to validate that information, and that's what we do as a standard. So we'll validate any hits that come back from the database to make sure it's accurate and that it also belongs to the right person, because if you have a common name, you don't want to attach a record to someone just because they have a name match. So we want to make sure we're giving you all that correct information. We also do county searches based off the address history, and that address history is going to be known through the Social Security number that we gather. And the counties that we search are based off of where they've lived. It's also going to cover the holes that the database might have, because the database does not have everything everywhere. So it's just a safeguard that we're covering at least where they've lived, and then anything that matches beyond that we'll also bring back. Sex offender registries of all states are part of that database, just to be clear on that. And we also run a government-sanctioned search that's going to check for well, different sources for anybody on a watch list through the government, whether it's a terrorist search or weapons of mass destruction. Things of that nature are part of that as well. And just a couple notes about IntelliCorp, just to give you an idea who we are. We've been around since '96. We are part of a larger corporation or enterprise called Verisk Analytics. That NAPBS accreditation I mentioned before, we are accredited through NAPBS, and only about 10% of their eligible companies are actually accredited. I believe they have somewhere around 750 members. So currently only a little over 10%, I think, now are accredited through that program. So what that means is those companies that have gone through that process of proving they have certain standards that NAPBS puts together, that we're meeting all those guidelines, and also helping our clients be compliant as well as part of those standards. So that's one thing that we do that is going to help you out as an employer. And then another piece of information, we do get recognized in the HR industry through HRO magazine, HRO Today magazine, and have for the last few years. So with that, I will open it up for questions.
Thank you so much, Matt, for a wonderful presentation, and thank you everyone for listening and for your questions. We have a question here. What is the average turnaround time for your background checks?
Well, the turnaround times are going to vary based off the type of background check. Well, when it comes to the criminal check, we typically say 1 to 3 days. And right now I believe our average for that criminal package is just about 48 hours, right under 48 hours. So within a couple of days, you should get that information.
Excellent. So we have a couple others. I heard that fingerprinting is considered the best search. How does your criminal search differ from a fingerprint check?
Well, that's a pretty good question. Fingerprint checks, there is a little bit of maybe a misunderstanding or a thought that fingerprints are the gold standard in the industry or for background checks. I would say that it's not necessarily better or worse than what we're doing. There's going to be holes no matter what you do. Now, the only thing is fingerprints sometimes are regulated based off of industries or states. Sometimes you do, or you are required to do a fingerprint. But the other thing is that fingerprint doesn't follow the same rules and regulations that a consumer reporting agency would have to follow. So when getting fingerprint information, you may get results on, say, arrest information. Actually, about 50% of their data is arrest information only. And you may get some information that you really shouldn't be using for your employment decision. So the onus is on the employer to decipher that themselves and make their decisions accordingly, where we would help with that because, first of all, we're regulated by the FCRA to give you that compliant information, but we can also help with that with some of the resources we have available.
Okay. And then the last question here. As an employer, how do we keep up with changing laws and regulations?
Well, that's a good question. There are things you can do to, a lot of things are available through the internet, obviously, but your provider of background checks should be able to help with that as well. For instance, in IntelliCorp, we have a full resource section for compliance and legislation And we can also help with documentation like the pre- and post-adverse action letters, disclosure and authorization, and things of that nature to help you with your documentation compliance as well.
Well, thank you very much, Matt. We don't have any more questions, and thank you everyone for tuning in today. This will be available as a recording for you when this presentation is over. Again, thank you so much, and have a wonderful day.
Thank you.